23039. All right, we're on record for a pre-trial review in this matter. I'll have to thank all the parties for their patience today. We've had a number of opportunities for sidebars to have a look at the case from a legal perspective, and they've been very accommodating. So thank you this morning. And may I have appearances, please?
Lee Heiss, lawyer guardian ad litem.
Good morning, Your Honor. William Amadeo, P76194 for the department, appearing via Zoom. My workers, please state your name for Judge Sala.
Megan McVeigh from the department.
Brittany Kelly from the department.
Michael McFarland representing mother.
Kaylee Youngke, mother.
Very good. We also have, I think, Dan Bartelt with us.
Yes.
Yes, welcome. Good morning. Thank you also for your patience. All right, Mr. Amadeo, comments about our sidebar?
Thank you, Your Honor. We did have two sidebars this morning. It's the department's position right now that we would be open to a reunification goal if Miss Youngke wanted to plead no contest to something. It's my understanding that she will not plead to anything. At this point, I ask, based upon all that, we set this for a jury trial and do a review today. I'll turn to my brother and sister counsel to see if that's an accurate recitation of everything.
It is.
It is.
All right, thank you for that. We've set a pretrial, a final pretrial, not necessarily a pretrial review because it's not our full 90 days, plus these children are with their parents, so we really don't need a review other than every 6 months. So we've set a final pretrial for Monday, October 23rd at 1:30. And we've set jury trial dates for October 30th and October 31st, commencing at 9 o'clock each day. That's for a jury trial. Jury trial request was filed back in February. So that's the plan moving forward. For purposes of today's pretrial review, Ms. Heiss.
Thank you, Your Honor. I visited with this child face to face, and she, a lot of factors combined to make her a very resilient child. She's healthy, she's developmentally advanced, she's so positive about school. It shows a lot about her environment. She wants to see mom more. We see the visit notes indicating how the visits go. I think that's positive for her. Overall, if dad would get a custody order, I think we could be assured that he can protect this child, but that's not something that's going to happen. Apparently, we can't get to that step. So because of that, to continue the case towards jury trial is something that makes sense for the child and to continue the visits. Thank you.
Mr. Amadeo.
Thank you, Your Honor. Department calls Megan McVeigh to the stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Mr. Amadeo.
Thank you. Good morning, Megan. How are you?
Good, how are you?
Good. Can you please state and spell your full name for the record?
Again, Megan McVeigh, MC, capital VAY.
And Megan, what is your job title?
I'm an ongoing Children's Protective Services worker at the Department of Health and Human Services.
And how long have you been doing that?
Almost 16 years.
Okay. And how long have you been on this particular case?
This particular case would have been about 90 days, about 30 days after the initial petition date.
And who's Brittany Kelly?
She is the investigating worker on the case.
And has Brittany Kelly worked on this matter as well?
Yes.
Would it be fair to say that you and Miss Kelly know more about this case than anybody else?
Yes.
What's the current permanency goal for the child?
The current goal is we've been doing reunification services with the mother.
Okay. And is there a concurrent goal or not?
No, because they're placed with a parent. She's placed with a parent.
Okay. Is Miss Youngke the respondent mother?
Yes.
Has she rectified the barriers that cause the child to come into care?
Not yet.
Can you explain to Judge Sal what services you offered?
Yes, she's been offered supervised parenting time with Pauline Edwards. We were able to make an intensive home-based therapy referral, which she has actively been participating in, that just started. And the the child has been seeing Renee Moore for counseling. And there's an additional service that we would like to get done. It's called a psychosexual assessment that's been recommended by the child's counselor to see if there's any risk of harm. Ms. Youngke is more than willing to do whatever she needs to do. It's just been a process of locating somebody that can do that assessment and getting it set up. That's been difficult.
Would it be fair to say that you don't want to dismiss this case at this point because you're still concerned about the child's safety?
Yes,
And would it also be fair to say that you still want to continue the investigative services you mentioned to the court?
yes.
Has there been a change in Stella's placement during the review period?
No, she's been placed with her father.
Okay, what's the current parenting time plan?
Right now, it started with one visit a week for 2 hours each week, and it's been increased to two-hour visits between the child and the mother, supervised by Pauline Edwards.
Has the placement exercised reasonable and prudent care during this time period?
Yes,
Being involved in this case, would a remedy that seems fair to you be reunification at some point?
at some point, it would be depending on the assessments and the recommendations from service providers.
So to be clear, you still would have some review to do. Is that accurate?
Yes,
Are there any additional needs the child that are not being met at this time?
not at this time.
Is there anything you want to add for Judge Sal to consider today?
Not at this time.
At this point, Your Honor, I have no further questions. I ask that the court report and supporting documents be admitted for the record.
No objection.
No objection.
Thank you. They are admitted. Questions, Mr. McFarland?
Maybe I'm a bit confused. Is in your position, you would not accept my client entering a no contest plea for the goal of reunification today?
That, I didn't know anything about her accepting a plea.
No, not. My question is, or is it your position that you would not accept no contest plea from her today with the goal of reunification?
I believe that would be a question for my attorney.
Okay, fair enough. This assessment that you've mentioned, how long have you been attempting to get that?
Since the last court hearing, it's difficulty finding a qualified professional. I believe I have found one, and it's been difficult scheduling. It's with Dr. Randy Haugen.
And where is he located?
He is located out of Battle Creek, but he does come to the Hillsdale County MDHHS, which would be a lot closer for Miss Youngke than Battle Creek.
You know anything about his schedule or the timeline for this?
Not yet.
So it might not even be completed prior, possibly.
In hopes it would be.
Okay, fair enough. With this minor child, are you aware that the child has had head lice 5 times and now has an active case of pintail worms?
Yes.
What are we doing to address that medical issue?
She went to the doctor to address the worms, and with the head lice, she hasn't, at this time, she does not have head lice right now, but she has had it a couple of times.
And what seems to be the cause there, you know?
I think they're really difficult to get rid of.
Yeah, apparently mom has been advised on that, correct?
Yes.
Has mom been invited to attend the doctor's appointment on that?
I'm not sure. I would have to ask Mr. Bartel.
Do you think that she does not have a right to be there?
She could be there, yes.
Has she been notified about that?
Yes, she was notified, but not by me personally, but Miss Youngke and Mr. Bartel are in regular communication with each other, and he keeps her well up to date on the well-being of the child.
And lastly, it sounds as though you indicated my client is willing and cooperative to participate in that assessment that you've mentioned, correct?
Yes.
Nothing further.
Ms. Hyde?
What is being done to investigate the source of these lice contaminations?
So I didn't realize that it had been that many times, but as far as I know, that it's been taken care of at this point. She didn't miss any school last year because of the lice concerns.
So it wasn't 4 over the summer, 4 outbreaks, it's 4 maybe total since January when we opened the case.
I don't know how many it's been, to be honest with you.
And then the worm situation, what's being done to investigate the source of that?
I mean, I wouldn't investigate the source of that. I would ask that the father take the child to the doctor to have the doctor address that, which he's reported that he did.
And what was the outcome?
I'm not sure.
Okay, and then,
That just happened a few days ago.
so this child has been seen by Brene Moore since about June, is that right?
Yes,
What was the delay in getting her into counseling support?
there was belief that she didn't need the counseling support. And then we had a court hearing where counseling support was recommended by the court, and we immediately started it after that.
So
She's been doing well in counseling. Ms. Moore feels that she doesn't necessarily need like every weekly counseling. She's very a well-adjusted child.
So if there's no risk of harm from her mother for mental health, is that what you're saying? Mother has not affected this child's mental health.
I think the concern is affecting the mental health of the siblings as well.
Are those kids in counseling?
Yes,
And can we see those records to know what they're working on?
I didn't include them because they're not a part of this case. They're not listed as a part of this case. But in Ms. Moore's letter that I attached, it talks about the concern between the child and her brother's relationship.
But certainly we're not removing this child from her mother because the boys might be jealous that she brings home a new toy.
No,
No.
that's not.
So we're removing this child from her mother because of the mother's risk of harm to the boy, at least to the victim.
Right, and the law also states what would be, we have to consider what is done to one child will be done to another child.
But we don't know what was done to the other child if you don't give us those records. So I don't know if he's in
I believe the
counseling.
records have been provided, like the CNC interview and all those, they have been provided, but I haven't provided the individual counseling records because they're not a part of the court case.
Do you have them?
I could get them.
Okay, I think they are part of the case because I can't tell if he's in counseling for a toothache or if he's in counseling because he's been sexually assaulted, and it makes a difference to protecting this child. So even if I can get a summary, you know, if that child is just distraught and on all kinds of medicine and not doing well because of the abuse and he's triggered and having all kinds of just trouble in school, that's different than this child who doesn't seem to even need counseling. So if you would provide me with some kind of an update on that child's progress, I don't need to know the details, so that I understand the harm to this child through understanding the harm to that child.
Right, and I can do that. That's not a problem.
Do you think this child is at risk for sexual assault from her mother?
I would have to defer to the psychosexual evaluation that was recommended, and I would go off of those recommendations.
But with no criminal charges pending, if she goes to the psychosexual evaluation, if she denies doing anything, that's not gonna be good in the psychosexual evaluation. Because she's in denial and not willing to protect her kid. And if she admits it, that's a crime, right?
Right.
So what do we do about that? How do you anticipate that she can win in a psychosexual evaluation?
I don't think there's winning. I think it would just be to evaluate the risk. And they would be provided all of the evidence from the court that the court's been provided.
And if she denies that she did it,
I'm not sure. I've actually, in the 16 years I've done this job, never done a psychosexual evaluation. So this will be my first one.
well, I don't know that it's realistic to expect her to do that when she has criminal liability if she goes one way, and if she denies, then she's got a problem here. I don't know how telling the truth, anyway, all right, so, but you did find a provider and you've got, is she amenable to, have you asked her if she'll do the test, psychosexual evaluation?
Dr. Halkin, I haven't been able to get a hold of him. We've been playing phone tag back and forth, back and forth, back and forth.
Do you think this dad is ready to supervise some visits, or do you think we still need the level of L&L parent aid for supervision?
I haven't discussed that with Mr. Bartel. I believe he did, at one point, they said that it would be okay. I think the concern would be like making sure it's not in the home where the other children are.
Absolutely, and Mr. Bartel could be prepared with when to shut a visit down, what not to talk about in a visit, and to provide us notes, whether mom's on time, if she stays the whole time, that kind of thing. Because he does supervise the video contact every day, right?
Yes,
The other thing that I'm looking for is whether we can trust Mr. Bartel to supervise in the absence of the pressure from the state. So you would consider getting him ready to supervise visits?
we could explore that, certainly. And I would also want to go off the recommendations of Brene Moore, but because so far we've been, and the last court order did say that the visits should be supervised and that there should be a recommendation from a counselor regarding the supervised visits. So that's where I have been going off the recommendation of the child's counselor.
And she's not really clear about, her recommendation doesn't say one way or the other about who should supervise, whether it should be professional level, therapeutic level. Or
I can get that recommendation from her.
Okay, that'd be fine. So I have nothing further. Thank you.
Any redirect, Mr. Everdale?
Briefly, thank you, Your Honor. Megan, there was a lot of talk about the criminal investigation. Let's just be clear. Is your concern a criminal investigation, or is your concern protecting the children?
Protecting the children.
And do you think it's possible, since this has been brought up on cross-examination, that just because Junkie was not charged criminally, there still may have been sexual activity that broke the law?
Yes.
And is your concern to make sure, based on the information you had, that these children are completely safe?
Could you repeat that, please?
Based on the information you have, is safety of the children your only concern right now?
Yes, yes, it is.
And do you feel the further investigation you need to do will help assure fairness across the board on this case?
Yes, I do.
Nothing further. Thank you.
Just a couple questions, if I might, Graham, following up on the guardian items. You're aware that this court usually affords parents 3 visits, 2 hours a week, correct?
Correct.
And my client's getting 2 visits, 2 hours a week,
Right,
correct?
and the recommendations of Ms. Moore, and according to the letter, at this time was 1 visit per week. So I've been going off the recommendations of Ms. Moore.
Well, we're actually exceeding that recommendation, right?
Yes.
So, and there's been no harm to the child, correct?
No.
So why not expand to the traditional 3 times in 2 hours if there's no exhibited harm at 2 hours, 2-hour visits per week?
I would say I've been deferring, going off of the recommendations of the counselor. And that's what her current recommendations are. She did make a recent recommendation after this letter that we could increase the visits because the visits have been going well.
Okay.
I don't necessarily have an issue with 3 visits per week.
So when do you anticipate that we could commence that?
As soon as we're able to set it up.
Okay.
And possibly, I mean, we could talk about Mr. Bartelt supervising a visit.
Okay.
That might make things easier for everybody.
And I am not familiar, as the guardian ad litem is not familiar with this sexual evaluation, assessment evaluation. Would it be possible for you to provide the contact information to me for this doctor so I can talk to him? Because I likewise am not sure, my client might want me present, might just take the fifth on all of this. So it may be just a waste of everybody's time. So I'd kind of like to find out ahead of time before we commit the doctor and my client to this, if you don't mind.
Yes, I can do that.
Would you also advise the doctor that I would be contacting the doctor after I receive the contact?
Sure. Yes, I can do that.
Thank you. And I don't mind if you're on the phone with me if you would like to be.
Okay, we can do that.
Thank you. Nothing further.
Any requests, Ms. Heist?
No, thank you.
Thank you for your testimony, and your time received. Any other witnesses, Mr. Amadeo?
No, Your Honor.
Nothing further?
Ms. Heist?
Nothing further, thank you.
Any comments?
Yes, Your Honor, I'll be brief. I don't know if the court can order the assessment, but if so, I know that's something my workers would like to do. We'll ask this go to review. We'll ask this go to a jury trial. And to be clear, because I didn't appreciate the, no offense to Mr. McFarland, but the mischaracterization, I've been very clear that if Ms. Yunke want to enter a no contest plea, we would have taken that. We would have went to reunification. It's my understanding that's not what she wants. She wants to go to trial. And respectfully, Judge, if this was a male respondent parent, we wouldn't be having the same conversation. My department's been over backwards to be fair in this situation. If she wants to go to trial, we'll accommodate. Thank you.
Any comments?
Court knows our position.
No comments, thank you.
Well, the court finds all interested parties were given notice for purposes of today's pretrial review. It's come to the attention of the court that at our last time we addressed this matter, the pretrial was adjourned, and it should also be noted that the jury trial was also adjourned to allow the parties to review some of the pieces of evidence that are relevant in this case, including a CAC video interview and some other pieces of information that needed an additional protective order to allow that to happen. So those things have occurred. The court has set a pretrial and a jury trial date. So those items are addressed and have a pathway moving forward. If the parties wish to address a resolution, then we'll have an opportunity to do that at the pretrial juncture. In the meantime, the parties have been operating under an agreement effectively that has kept this child really from being removed or under the formal jurisdiction of the court. And that included the agreement between the mother and the father to have virtual visits, to have visitation, but all supervised. And at the last juncture, of course, the directive to have father get the child enrolled with a counselor to have a professional weigh in about visitation and whether or not there remains a risk of harm associated with allowing this parent unsupervised time with the child. It's come to the court's attention that there will not be criminal charges being pursued, at least at this juncture. That's the understanding of all of the parties against the mother. L&L parent aid visit observations do not present any real concerns. I'm looking at the letter from Ms. Moore. It does not really seem to indicate that there's a risk of harm associated with parenting. She expressed some observations about the child, but not really any indication that there's a risk. She does indicate, as Ms. McVeigh shared with us today, that it could be beneficial for Ms. Yunke to have a psychosexual assessment to discern the risk of harm still during visitation. And really, given the allegations, it's about whether or not those particular choices or the lack of boundaries, and assuming the allegations are all correct, it would be whether or not that decision-making process presents a risk of harm to this child, right? So I can see the benefit to having the psychosexual assessment. I'll note in the order that we'd like the department to explore that to see if we can find something to do that for us. But in the meantime, I would like the visitation expanded. But again, this is all based on the agreement of the parents. I think we have an assumption here that the department has the discretion to oversee parenting time, but we really don't. So it'll be up to Mr. Dan Bartels and mother to determine that. Would appreciate you continuing to observe the supervised aspect of that until we can get the psychosexual assault assessment, in place. And please make sure that you communicate with Ms. McVeigh about any parenting time that you arrange. But I can't see a risk of harm at this juncture associated with increasing the time that you're spending with your child. So those are my comments on that point. So I'm not ordering anything because I don't have the authority. I'm asking you to continue to respect what the two of you have agreed to so far, which is Don't spend any alone time with your daughter just yet until we get one more assessment done. And hopefully we'll have an answer to which direction this case is going in late October. So I appreciate the parties continuing to respect the court and respect each other and the child, and put her first, abiding by their safety plan. And I do think Ms. McVeigh is certainly making efforts to monitor the situation and provide services, so thank you. And thank you also to Ms. Heiss for her vigilance on behalf of the child. So we're all in satisfaction of our obligations here. Let's get some answers on which way this case is going in October. And unless there's any questions, that's all for today, and we'll see you on the 23rd.
Thank you, Your Honor.
Thank you.
I'll have a copy
Have a good day.
in just a few minutes.